Oh, hi there. Got a couple of things to share with you today to do with the Sean Ellis case. Why are we not surprised at, first of all, the response by the police department? Let's click on that. Just make sure that I've got the right one. Just one moment. Yes, sure I've got the right one there. Okay, let's pop that up there. That up there. So this is a message from Boston Police Superintendent-in-Chief Gregory Long, March 17th, 2021. The reprehensible and corrupt behavior of 3 former members of the Boston Police Department has caused the conviction in the 1993 murder of Detective John Mulligan to be overturned. Those 3 detectives not only disgraced themselves, but unfortunately their conduct was used to tarnish the reputation of the entire Boston Police Department. Immediately I'm struck by Rosemary Scapiccio's comment about the fact that, corruption didn't start and end in the Sean Ellis case. The Boston Police Department does not and will not tolerate corruption. Are you sure? Every day, the members of the Boston Police Department proudly wear their uniform to serve and protect the people of the city. In this case, the actions of a few have significantly impacted the image of the countless members of the Boston Police Department who worked tirelessly, honestly, and honorably to bring justice to the Mulligan family. As Justice Carol Ball stated in her 2015 decision granting the defendant a new trial, the conclusions reached here should not be read as an indictment of the many honest and honorable Boston police officers who worked on the Mulligan murder investigation. Moreover, 20 years after these events, this judge is acutely aware of the strides made by the Boston Police Department in the professional handling of the investigation and prosecution of their cases. This is particularly true of the homicide department, which is deservedly held in particularly high regard by this judge. Aware of the strides made, there's an admission there that there's a problem. Recognizing the issues that surround this case, the Boston Police Department's belief remains the same, that there was sufficient credible evidence to support a conviction for illegal firearm possession. As Judge Ball stated in her 2015 decision, the motion for a new trial is denied as to the firearm convictions, as no real doubt as to the justice of those convictions has been established. In closing, and most importantly, the department wants to acknowledge the continued pain and suffering of the Mulligan family. No mention whatsoever of the pain and suffering that Sean Ellis has been through. Our support for them has never wavered. Is that it? Yeah. Pretty ropey response. Pretty poor. Pretty poor, No mention of any apology to Sean Ellis for wrongfully convicting him for all those years. Anyway, here's the decision that I was looking for following the previous article. This is the most recent memorandum of decision and order on assented to motion for new trial. The judge starts, despite the overwhelming undisclosed exculpatory evidence that led the Supreme Judicial Court to uphold the grant of a new trial on defendant Sean Ellis's September 1995 murder and armed robbery convictions, see Commonwealth versus Ellis, Massachusetts 459, 2016, Ellis remains convicted of unlawful firearms possession for the simple reason that the firearms conviction occurred at an earlier trial in January 1995. The court held a hearing today on Ellis's motion for a new trial on the firearms conviction. After reviewing the above noted SJC decision, the SJC's 2000 decision affirming Ellis's convictions, see Commonwealth, the submissions of the parties, and a letter from the victim's family, this court agrees with Ellis and the Suffolk County District Attorney's Office that Ellis's January 1995 trial was fundamentally unfair and justice was not done. Therefore, Ellis's motion for a new trial will be allowed. Now, this is when I start to get really annoyed. A court may grant a new trial at any time if it appears that justice may not have been done. The standard under Rule 30B is intentionally broad, and the disposition of the motion for new trial is left to the discretion of the motion judge. However, a strong policy of finality limits the grant of new trial motions to exceptional situations, and such motions should not be allowed lightly. Well, that's very, very good. But what really gets on my nerve is the fact that it was a stupid, pathetic kangaroo court that convicted so many people in the first place, like Sean Ellis, like Stephen and Brendan, and like so many other people. A complete farce of a kangaroo court that convicted these people, and yet they're saying that the standards need to be really high, exceptional situations, because of this thing about finality. It is very, very annoying. You know, let's have a proper trial in the first place, then you wouldn't need any of these appeal situations. A court is to apply the standards set forth in Rule 30B rigorously and should only grant such a motion if the defendant comes forward with a credible reason which outweighs the risk of prejudice to the Commonwealth. Yet, as I say, why not have a proper trial instead of a kangaroo court in the first place? A defendant seeking a new trial on the ground of newly discovered evidence bears the burden of demonstrating that 1, the evidence is in fact newly discovered, 2, the newly discovered evidence is credible and material, and 3, the newly discovered evidence casts real doubt on the justice of the conviction. You know, you can't help read this and think immediately of Steve's case and what Kathleen is trying to do with that. Anyway, the ultimate inquiry is whether the newly discovered evidence casts real doubt on the justice of the conviction, not because the verdict would have been different, but rather because the new evidence would probably have been a real factor in the jury's deliberations. In other words, there's a danger that the trial might have been fair and not some jumped up kangaroo court. Application of the legal standard. At his January 1995 trial, Ellis had none of the exculpatory evidence obtained long after his trials that led Superior Court Judge Carol Ball to grant Ellis a new trial on the murder and armed robbery convictions, and the SJC to affirm Judge Ball's decision, as set forth in Ellis 2. This exculpatory evidence included the following: information regarding the theft on September the 9th, 1993, 17 days before the victim's death, of approximately $26,000 from Robin Martin by detectives Robinson, Achira, and Kenneth Beers. Sergeant Detective Leonard Marquardt and the victim Martin theft. 2, Federal Bureau of Investigation informant reports, FBI informant reports, describing criminal activities by the victim. 3, information regarding an allegation by Boston Police Detective George Foley that the son of a Boston police officer had told him in late August 1993 that his father was going to kill the victim because the victim would not leave the son's 14-year-old sister alone. Foley allegation. 4, information from Boston Police Anti-Corruption Division, ACD, files regarding Detective Robinson and the victim together robbing two mid-level drug dealers of a large sum of money in or around May of 1992, drug dealer robbery. 5, information from ACD files regarding the victim obtained through Ronald Hansen report, describing criminal activity by the victim, and third-party knowledge of victim carrying a .25 caliber gun at his ankle, and 6, tips from the Boston police hotline established after the victim's killing to obtain investigative leads, hotline tips, suggesting that someone other than Ellis had committed the murder and armed robbery. As the SJC explained, the judge concluded that these 6 categories of newly discovered evidence show that the investigators failed to vigorously pursue other leads, and when combined with evidence of the conflict of interest of Achera, Robinson, and Brazil, formed the basis for a potentially powerful defense under Commonwealth versus Bowden, that the police failed to pursue leads that could have identified a different perpetrator. The conflict of interest the judge identified was that detectives Brazil, Achera, and Robinson had a personal interest in solving the victim's homicide as quickly as possible before any members of the task force who were not part of the corruption scheme or anyone else could look further into why the victim may have rubbed people the wrong way or was rumored to be a dirty cop. In other words, they needed to prevent others from finding out that they and the victim had been engaging in illegal activities. The judge stated that with this newly discovered evidence, the defendant could have argued that the corrupt detectives compromised potential evidence of their identifying of the victim's killer while attempting to conceal evidence of their own wrongdoing. The judge also found that the newly discovered evidence would have further supported a powerful Bowden defense by revealing that the Commonwealth failed to investigate numerous other parties with reason to kill their victim. Such a defense could have raised a reasonable doubt as to whether, as the Commonwealth claimed at trial, the defendant decided to kill the victim simply because the opportunity presented itself. The judge concluded that the newly discovered evidence of the conflict of interest of Achera, Robinson, and Brazil, and the Boston Police Department's failure to follow up on leads implicating third-party suspects is material, credible, and would have been a real factor in the jury's deliberations, such that this is a case where justice has not been done. Just as the above noted undisclosed evidence would have been a real factor in the jury's deliberations on the murder and armed robbery charges, it would have been a real factor in the jury's deliberations on the firearms charge, which involved the same events and the same investigation. The court has considered Ellis's concession at his 1995 trial with regard to the firearms, but this was a strategic decision made coffee gone down the wrong way. But this was a strategic decision made at a fundamentally unfair trial. That's better, in order to maximize Ellis's chances of avoiding conviction on the murder and armed robbery charges. A defendant's concession at a trial rigged against him, that's more like it, that's what we want to hear, rigged against him, made with the hope of avoiding conviction on far more serious charges, has no more credence than a defendant's unlawfully coerced confession and provides no grounds to deny Ellis's new trial motion. Since the SJC's ruling in Ellis 2, new previously undisclosed evidence has come to light that further undermines the fairness of Ellis's 1995 trial, including payments to 3 Commonwealth witnesses and problems with the Commonwealth's fingerprint evidence. That's what really annoyed me, that they're paying witnesses Although there have been no formal findings about the extent to which this additional evidence is credible and material, the credibility and materiality of at least some of this evidence is self-evident. This additional evidence is not necessary to the court's ruling, and there is no good reason to delay a decision on Ellis's new trial motion. Ellis has clearly met the standard for granting a new trial of the firearms charge. Justice of the Superior Court, Robert Ullman. Okay, I think that's worded much better at the end of the decision, acknowledging the fact that, the trial was, just unbelievably unfair, rigged. I like that word. It was rigged. And that's, the parallels between Sean Ellis and Stephen Avery and Brendan Dassey are there for everybody to see. It's incredible, isn't it? Anyway, hope you enjoyed reading those. I might just leave the links to both of those articles in the description. Anyway, thanks for joining. We'll see you again soon. Bye for now.